If you're watching this video right now, the chances are you're going through one of the most difficult times of your life. You might be thinking about separation, you might already be separated, or maybe your partner has just told you they want out of the relationship and you have no idea what happens next. I want you to know something. The process is not as frightening as it feels right now, and there are some clear steps and framework. There are rules, and once you understand what those steps, the rules and framework looks like, it'll all feel a lot better. My name's Leanne Abela, and I'm the Principal Director at Pearsons Lawyers, and I've been practising in family law for 40 years, that's 4 decades, and I've helped thousands of people over those years navigate exactly what you're going through now. In this video, I'm going to walk you through the entire divorce and separation process in Australia, step by step, so it's clear to you. I'm going to show you and describe what happens from the moment you pick up the phone and contact us, all the way to the solution. No legal jargon, no scare tactics, absolute clarity, so you will know where you stand. Now, before we get into the steps, there's one thing I need to clear up, which is often confusing and mystifying for people. People use the word divorce and separation interchangeably, but they are not the same thing. Separation is when you and your partner decide the relationship's over. And that can happen even if you're living under the same roof. There is no form to fill in or document to sign. You simply stop living together as a couple, either under the same roof or separately. Divorce is when you are formally ending the marriage and you have to be separated for 1 year. And that's quite simple. All you have to do is demonstrate that, and then the court will grant you the divorce after the 1 year. And that's all. Here's what most people don't realise, that the divorce itself doesn't separate your finances or sort out your children and other issues. That's the separation process. And that's where most of the heavy lifting and the work happens. So when people say, I'm going through a divorce, what they usually mean is, I'm separating. And you can be a de facto couple or a married couple. Working out arrangements for the children and child support and separation process and spousal support and property division is what this video will be about. So why don't we walk through exactly how this actually works. Step 1 is when you pick up the phone or make an appointment online with one of our lawyers. At Pearsons, your first appointment is obligation-free. It's a 30-minute consultation with one of our lawyers where we sit down with you, and you can certainly bring anyone you want to that appointment except for your former partner. We listen to you, we answer your questions, we explain where you stand, and we raise any red flags you need to be aware of, with plenty of time for questions. Because we're so experienced, we can cover all of the topics. We discuss, what does the property pool look like? What do the children need? Are there businesses, superannuation, investments? And we talk about any safety concerns that need to be covered. This isn't about making decisions on that day. We'll explain to you legally where you stand, what your options are, and what you can expect. We'll go through the steps. By the end of the first meeting, most people tell us what a relief they feel, how scared they were initially coming in and not knowing the process, but what a relief it is now to have spoken to a lawyer and know where they stand. If you decide you want us to act for you, then you can become a client. There is a process as to how you pay, or as you go along, or at the end of your matter, with many options in between. And of course, everything you tell us is privileged. We will get to work straight away, and we work as a team at Pearsons. Once we've taken your instructions, the next step is making contact with the other side. If your former partner already has a lawyer, we will write to that lawyer directly. But if they don't, we'll write to them personally. The initial letter is very professional and measured. We keep in mind everybody wants to reach a resolution without court if possible. We're simply letting them know that we act on your behalf, that we'd like to start the process of resolving the matter and commence negotiations. And we tell them what we need to be able to do that. A lot of people worry about this part. They think it's going to feel aggressive or confrontational, but it's not. It's a professional communication that explains that you want to settle cost effectively, efficiently, and amicably. And frankly, it often comes as a relief to the other side as well, because it means that they know the process is underway, rather than everything just sitting in limbo and not knowing what's going to happen next. So the next process is that we would then ask for disclosure. This is a really important part, and let me explain why. Under the Family Law Act, both parties have a legal obligation to provide full and frank disclosure at all times. That's of their financial position. It's not optional, it's a requirement. And what that means in practice is that both sides need to put all of their cards on the table. That's bank statements, superannuation statements, tax returns, any property valuations, business records, if there is a business involved, trust records, that sort of thing. Everything that gives an accurate picture of the financial position of each party. We do this for you. We make sure the other side does it for them. So what we do is we help you obtain those records, and we speak to you about how you can collate them and obtain them, and we make sure the other side hasn't missed anything. If something is missed, we ask for it. If something doesn't add up, we dig deeper. This is where having an experienced lawyer really matters, because we know what to look for and we know what questions to ask. We're also very innovative at Pearsons, and where possible and appropriate, we use various innovative techniques by using paralegals and our experienced secretarial and paralegal staff who are very well trained for decades in this area, and we also use AI when appropriate. The disclosure process can take a few weeks, sometimes longer, depending on how cooperative the other party is or how complex the financial picture is, but it is essential to drawing a map of what is in that property pool to divide. You can't negotiate a fair outcome without the complete picture of what's on the table. So that is a very important step. And we try to get there as quickly, cost effectively, and painlessly as possible. Once we've got that full financial picture, we then move on to the next step, and that's putting together a proposal. And although it doesn't matter who puts forward the first proposal, we don't want to be wasting time and we want to move the matter along. So we'll ask the client, would you like to put the first proposal forward, or would you like us to ask the other party? It's your case. You are in the driver's seat and we're helping you. This is where we sit down and work through what we think a fair and reasonable outcome looks like, taking into account incomes, asset pool, and various factors we're going to consider, and I'm going to explain. We'll consider the property pool, which is everything both parties own, from the house to the superannuation to the debts. We look at the contributions that each of you have made, both financial and non-financial, which many people overlook and don't take into account, as it's not as tangible as someone's salary or someone's tax return, but it is as equally as important. And we consider future needs, things like health, age, earning capacity, who has the primary care of the children, who has the greater earning income ability. Based on all of that, we put together a proposal that we present to the other side after you have had an opportunity to have an input into that and to understand it fully as a result of the expert advice you're getting from our team. We cover the division of the property, we cover spousal maintenance considerations, and if there are children, we cover child support aspects as well as parenting arrangements. And we work out and explain to you how that impacts on the percentage split. Now, at first, the other side might accept that proposal, and if so, the process is pretty clear from then. But they might come back with a counter proposal, and that's completely normal. Negotiation is a process, and often there's a few rounds of back and forth before both parties reach an agreement. The important thing to understand is that most family law matters in Australia settle through negotiation. Most people do not end up in court. So don't listen to all of those stories you've heard from someone at the shopping centre or your best friends, because everybody's case is individual. The circumstances are different. The facts are very different in every case, just as every separation is different. What you need to know is that at Pearsons we are certainly geared towards trying to settle first, if possible, without having to go to court, unless it's urgent or necessary. The vast majority of cases are resolved through the process of proposal, negotiation and compromise, something that you can live with. Not always perfection, although we do aim for excellence here, that is for sure, but we also understand people see the bigger picture and part of their lives and will compromise for reasons best known to them that works for their family moving forward. And that's a good thing, because reaching an agreement through negotiation is always faster, less expensive and less stressful than going through court. And generally, because both parties have come to that agreement, moving forward in their lives, there are many benefits, particularly if there are children. It might mean you can both be at your children's wedding, graduation, birthdays, and for the children to be able to see both parents there may be something you value more than money in certain circumstances. Once both parties have agreed to the terms, the next step will be making that agreement legally binding so that you can move on with your future life financially, not looking over your shoulder, and knowing that whatever occurs next is not vulnerable and is protected by that legal agreement. Because a handshake or a signed letter is not enough. You need a formal document, and there are two ways to do that. The first and the preferred method is called a consent order. This is where the agreement the two of you have reached is set into a set of court orders and an application. Each of you signs off separately, and actually only one lawyer is needed who prepares the document, and then the other party will sign. So it can be more cost effective as a couple, and many people opt for an application and consent order for this reason. We will then file those documents with the Federal Circuit and Family Court, and a registrar will look at the documents and the application that was prepared to ensure that it's fair to both sides and within the range of what a court would expect to have ordered. And they'll approve it, put a beautiful red stamp on it, and you'll receive a copy. And that will be the end of your financial relationship. Once approved and stamped, it has the full force of a court order, which means it's enforceable. It also sits at the court forever. The second option is what is referred to as a BFA, a binding financial agreement. This is a private contract between you and your partner, signed outside the court without the approval of the court. And each party has to have separate lawyers, separate independent legal advice before signing. It is legally binding, but it is not held with the court, it is not approved by the court, and it doesn't have to necessarily be within the range of what a court would approve or order, because it's not going through the court process. And that is one of the reasons some people opt for a BFA. If, for example, one person wants to give the other party the house so that the children can live there, that would be in a BFA, because the court may not necessarily approve that. So it gives you greater flexibility to be creative and perhaps do something that is a bit left of field. Your lawyer will advise you which option is best for you, and the cost is almost the same. Both achieve the same goal, that is a legally binding resolution to your financial matters, and allows you to move forward. The advantage of the consent orders, as I said, is only one lawyer needed who doesn't act for both parties but acts for one of them without the other person needing an order. It is held by the court and stamped by the court, and also you can add children and parenting in, whereas you can't with a BFA. So there's a few advantages and disadvantages which will be explained to you at your first appointment. Now, I've just told you that most matters settle through negotiation, and they do, a huge percentage. And in about the 1,500 cases that we do every year, I would say about 1,200 of those settle by consent. But there are some that don't. And so what you need to know is what happens in that situation. Sometimes, despite everyone's best efforts, parties cannot reach agreement, and there's good reason for that. Maybe there's a disagreement about the value of a business. Maybe you disagree as to who should keep the house or what the arrangements should be regarding the parenting and the children's arrangements. That is a legitimate dispute, and sometimes the umpire has to decide despite everybody's best efforts and despite various negotiations and mediations, the umpire being the judge. Maybe there's a dispute in relation to a particular aspect of parenting that one person won't budge on. Maybe one party just won't engage in the entire process and the matter's got to proceed on an undefended basis. There's always a solution. When that happens, the next step is usually mediation or family dispute resolution for parenting. This is a process where both parties will sit down with an independent mediator. That's a trained third party, sometimes a former judge or registrar of the court or a barrister, and they will try to work out the issues together. They can either go on their own, or some of our clients say, hey, I would like you to come with me. I would like a solicitor there for guidance. Some will say, I'll go on my own, but I'll check in with you through the process if I need you. The option is yours. We provide many different models and options for clients depending on their individual needs. As I said, every separation is different. Now, for parenting matters, you are actually required to attempt family dispute resolution before you can file an application with the court. There are some exceptions to that, and that might be family violence, being an intervention order, or an urgent situation where you need to recover a child who's been removed from the state or the jurisdiction, or where the child might be at risk as a result of being with a particular parent after a separation. If mediation doesn't resolve the matter, then you can look at making an application to the court. This means filing what is referred to as an initial application and an affidavit. The court process involves various case management conferences, directions hearings, mention hearings. They're all the interim stages which allow for negotiations at each step with the other party or their solicitor, and allow for directions and orders by the court in how the matter will proceed and be managed moving forward, with various options such as a family report by a specialised person who understands children's matters, or obtaining valuations so that you can proceed to a financial negotiation, valuing a business, valuing a property, a disclosure orders when someone hasn't engaged or participated properly and completely in disclosure. Various other stages take place before a final hearing. But here's what I want you to take away from this. Even if a matter proceeds in court, it usually settles before a final hearing. Only about 5% of cases will go to a final hearing. The court process itself creates options, structures, deadlines, a pressure on people to really comply and make a bona fide, genuine effort to try to negotiate and settle. The framework is great. The framework provides predictability and provides rules and directions as to how the matter is going to be managed. And that timeline is often what people need. And if it does go to a hearing, you'll have an experienced family lawyer from our firm beside you every step of the way, presenting evidence, presenting your case and advocating for you, either themselves or with an experienced barrister that we've selected which best suits your case. So that's the process from picking up the phone and having your obligation-free first appointment, understanding your situation, disclosure, negotiation, and resolution. There are some really clear steps, and there are experienced people in our office who've been with us for decades, from our receptionist right through to our support staff. They will look after you. Every client is important, they have knowledge, and they care about people. Your immediate contact with our office will make you feel like you are in excellent hands. They will help you every step of the way and guide you through every step of the process. So, if you're watching this and you're at the beginning of this journey and in a haze or in a fog and not knowing what to do, Or if you're somewhere in the middle and not sure if you're on the right track or getting the right advice, the best thing you can do right now is talk to someone who understands the process, get a feel of how we operate at Pearsons, and make a decision as to whether you want to onboard with us or change lawyers. That's an option too, or just get a second opinion. At Pearsons, your first appointment's free. It goes for approximately 30 minutes. You can have a longer one if you desire to do so and pay for that. It's confidential, it's privileged, and there's no obligation. We'll sit down with you, listen to your situation, and explain exactly where you stand and what your options are. And you're doing that with an experienced lawyer. We've been helping families through separations for over 100 years. We have 17 offices across Melbourne, and we're here because we understand that this isn't just a legal matter. This is your life, your family, and your future. And quite frankly, there is nothing more important. Some people come to us not because they're separating, but because they're about to enter their first serious relationship or their second or third, and they want to know what they should do to protect themselves or what the risks might be. That's an area we cover as well in the first free appointment. So, if you think that you are the right client for us, or you would like to see what it's like to work with a Pearsons lawyer and the Pearsons team, you can book in your free appointment either by going to our website, pearsonslawyers.com.au, or call us on 1300 699 688. No one will know you've called except for our team. Everything will be confidential, and quite frankly, you have nothing to lose by getting that free piece of tailored, customised advice. My name's Leanne Abela from Pearsons Lawyers. Thank you for watching, and remember, knowing where you stand and having that knowledge is the first step forward.